So our next speaker needs probably little introduction. So Bartha Knoppers is the director at the Center for Genomics and Policy at McGill University, and has also played a leading role in running the research and the regulatory and ethics working group. So she's going to be talking on variant databases, tripartite responsibilities.
Thank you. Good morning, everyone. So it's my pleasure to talk to you about a subject that I think actually instills more fear than positive passion. That's the question about variant databases. Who's responsible for what and when, and what does the future look like? I'd like to begin by thanking my co-authors, both of whom are in this room, Bob Cook-Deegan and Adrian Thorogood, and we will have a publication coming out in about 3 weeks on this subject. So my talk is inspired by our article. As mentioned by Nikki, we have the Regulatory Ethics Working Group, and since there's half of the people in the room are new members, this working group is co-chaired with Kazuto Kato and myself, and has a great number of task teams and projects on the go. Any of you interested, please do join us. I think you'll find the discussions lively and interesting, if not controversial. The most controversial thing that we did at the beginning of this network, of the whole creation of the alliance, was to completely flip the traditional ethics policy approach on its head. We decided that instead of saying or building a foundation for the alliance on a presumption that research is harmful and somehow we have to overcome it through codes of conduct, through sort of making clear that we're actually not harming people or trying not to harm people, that we would take an approach based on the right to benefit, the right of citizens to benefit from science and its applications. So we decided to take a human rights approach. Someone has told me that this is disruptive, and I hope it is. So this right to science has its origins in the Universal Declaration of 1948. And as you can see, it actually has two parts. We've sort of concentrated in the first 3 years on the first part, which is the right to benefit. But the second part in the same article is about the right of contributors, scientists with intellectual curiosity and so on, to be recognized for their contribution. So while we want to share, we also need recognize the need to attribute. This is important. It's not just a universal declaration. In 1966, it became a convention. This article was in an international convention that was signed and ratified by 164 countries. This takes it to a level of legal actionability. This right is dormant. It's not even nascent. We have to activate it, and I think the Global Alliance, by taking this approach of a right to citizens to benefit, can finally have a sea change in how genetics, genomics, and data sharing, medical data sharing, is done. We have translated the framework, all volunteers, all validated translations, by the way. We have now, including English, we're up to 13, and I met someone at this meeting who's going to do the Korean translation. So we're moving on. It's a simple document. It has simple principles and 3 procedures to help in its interpretation. The Regulatory Ethic Working Group also has policies, and you can see them here. Do look at them. The latest is the Data Sharing Lexicon, which is available outside. The Regulatory and Ethics Working Group also supports the projects, and here's where I get to my subject, finally, this long introduction. And the 3 projects are the Beacon Project, the Matchmaker Exchange, and the BRCA Challenge. And it's in the BRCA Challenge that is building a tool called the BRCA Exchange that we were asked to look at the question of liability, which I call responsibility. If you say liability, everyone gets scared. So what's happening in the BRCA Exchange right now is that it's being built. It was a great meeting we had yesterday, very inspiring meeting. And the goal is to have 3 different spaces within this exchange. One where there's a consensus on variants that have been curated by an international panel using databases or groups such as Enigma, and curating the data to their best ability in a reasonable expectation of their best ability to make that publicly available as a support tool for clinicians. And I say support tool. Clinicians still have to think about their patients in front of them. Then there's a public research space where really there's a portal where you can access different variant databases around the world in an easy way, but they're not really BRCA exchange reviewed or curator annotated, so each remains in their current state with their own current responsibilities. And then we're creating an expert space where there will be a registered access, as was just mentioned, is under definition right now, where there will be restricted access. You can actually work together in a confidential way on doing the actual curation. I actually found out and remembered that I actually wrote on this subject about allelic variation databases over 16 years ago. Couldn't remember. And then again in 2005 with our dear departed friend, Dick Cotton. So the idea about who's responsible for what in these variation databases is not new. And then the Human Mutation of the Human Genome Variation Society in 2010 came up with 10 points. And there's one point that I find interesting on here, and that is the point where it says in number 11, I don't know if it's readable, most of it is traditional kind of think about this, think about that, don't do this, or be careful with that kind of language, is limit links to other locus-specific databases. And I'm wondering, standing here today at the Global Alliance, I think we've now moved from that to trusting, as we heard this morning, to sharing, to creating the commons that's necessary to make these databases more quality, greater quality, but also more accessible. So that's the good news. What has happened? Well, in the last year, there's a case here, I'm not in the United States, in the United States called Williams versus Athena Diagnostics. A little boy born in 2005 had symptoms of epilepsy, and it's usually treated with anticonvulsant medications, but they can be contraindicated in certain forms of epilepsy. And it was discovered later that he had Dravet syndrome. But when the report came back from the lab, they said that the little boy in question had a variant of unknown significance. Now, these are all allegations. As a lawyer, I have to be very careful. These are all allegations. Hasn't gone to court yet. It will, though. And the boy continued to receive what we now know is contraindicated medication and died from his seizures, so that at the age of 3. And the mother is suing for wrongful death. So the allegations say that Athena failed to provide an accurate genetic result. It failed to update its variant classifications. So what is the standard of care? Who sets the standard of care, and what is it? If you're going to be held accountable, which is normal, is this true that Athena, we will find out the actual, when the case is actually heard. But Athena was alleged did not follow its own classification system. In fact, some of the persons associated with that company had specific knowledge and had written on that particular variant and had even been involved in a patent application on that particular variant. So where are the duties? I mean, traditionally, there's 4 duties for physicians anyway, and as we know with the translational medicine researcher, clinician, researchers from the physician through the healthcare learning system back to the clinicians and the researchers and so on. To inform, to treat, to hold confidential, and to follow are the classical 4 duties. But these are changing. I mean, today a lot of genetics, the information is the treatment. What does the duty to follow mean, especially when things change in terms of classification and interpretation? And whose duty is it to inform? Are you supposed to send out alerts so that physicians call in their patients and so on? And whose duty is it to update and how often? So that's why the title is a tripartite responsibility, because if you look at this diagram, you start at the beginning with the quality control, quality assurance. And in a lab, you can really control your parameters, you can calibrate and so on. You have the zone of risk of error can be quite constrained and circumscribed. So there is a duty there, and we know that. But then when we come to the interpretation, especially if we want to make it publicly available in a publicly available variant database as a support tool, what are the duties of the curators, annotators, and interpreters, and so on, in addition to provenance and where the information came from? And what about the physician? The physician is, after all, a professional, someone who's not a garage mechanic finding this piece that goes into an engine somewhere. Professionals interpret. They take the individual, the context, the family history, and so on, and they have also a role in the communication and interpretation of that information. Now, currently, if you go to variant databases, you'll see statements, we are not responsible for the quality and so on of all the submissions that we have received. They remain in the hands of the original submitter. Or you'll find disclaimer clauses, or you'll have to sign saying that you will not sue, and so on. I have to warn you, there are some countries where those kinds of clauses, those waivers, are not considered legal when it comes to cases of bodily harm. Now, we know in genetics, no person, no lab technician, interpreter, or physician causes the disease. And so this is a particularly interesting case because there's all kinds of different points where there will be allegations about who did what and when and who should have relied on what, or was it actually the physician who was the final interpreter of the duty to diagnose. Now, we have an accountability policy in the Global Alliance. It addresses more, not this responsibility in terms of liability issues, but the duties of all the different stakeholders. So when this variant database issue comes to court, the sharing, if you like, of that responsibility across the different partners is going to be an important issue. But what's unique about, about this policy is that, like the consent policy that brings up issues of legacy data, can you use it? Yes. Like the privacy policy that says, please use a proportionate approach. We're not dealing with clinical trials here, so the risk-benefit ratio is different. The accountability policy also says, why are you not sharing your data? Hence the need for public variation databases. So to conclude, I'd like to remind you then that when we're talking about responsibility, it's really important not to get down to the level of what I call liability, that the mission here is really to benefit, and that the risk is a shared risk amongst the whole community. So I don't think that what the Regulatory and Ethics Working Group has called the red herring of legal liability should stop us in our efforts. The CanShare project here in Canada is supporting in part some work in the demonstration projects, but most of the work of the Regulatory and Ethics Working Group. It's a P3G-led project. And the latest contribution has been a response to the FDA's request for comments. As you know, the FDA is working on a policy to regulate next-generation sequencing tests, and in particular, sort of branding what could be called an FDA-recognized public variant database that would provide evidence of clinical validity for NGS test submission. And go on the website of the Global Alliance, we have submitted two comments to the FDA. And one of our comments, and I think the one that attracted my attention, very carefully drafted by Adrian Thorogood, is that the Global Alliance recommends that the FDA work to establish an international recognition process. It's not enough. It would be great to have it here in North America, the United States, but it's international. I mean, research is international. So how do we establish such a recognition process? And the Alliance will be working, hopefully, with the FDA if they accept our offer. And to conclude, we propose as an alliance that the variation modeling collaboration work with the FDA to set standards for the computational representation of variation that is used to exchange data among recognized variation databases. So keep posted and keep positive. And here is the P3G and Center of Genomics and Policy staff at your service. Thank you.
Questions?
As a person who publishes all the time on classification of variants in disease genes, that case really struck a chord with me. And one of the things that I know is that when I publish a variant and say that it has a certain effect, there's some element of time before that gets accepted by clinicians. So just because it's in the public doesn't mean that it's being treated in that way, because we all know that there are a lot of other papers out there that are rubbish, that may say wrong things, and so there needs to be a body of support by a whole lot of people. And then the other comment to make is that there's a lot of information we use right now to guide our clinical treatment of patients with hereditary diseases that is not published. And so I think that case is really interesting, if that should be known. Even if I have published on something doesn't mean that right now I have all the support of all of my colleagues. So I'm in a way, I back Athena in this one, in that you need to have everyone behind you to say something is disease causing.
Yeah, and you bring up a point that courts looking at this will look at what was the practice at the time. You're not allowed to judge a person through hindsight. Oh, today this is the way we do things. This is the good way to do, or the way we've decided to do things. The decision as to what was where the responsibility lies will be taken according to the professional norms that were available in 2007. So that is a good point. And if you look at the FDA guidance questions, you'll see that they actually examine the issue of should there be updates, and you can't turn clinician researchers on a hunting expedition to find when things change. I worked in a bookstore. I sold the Merck manual. I remember when a new Merck manual came out. Remember the blue thing, the paper thing? Probably before your time, but and so yeah. So will it be an annual sort of obligation to sort of clean up and you know, refresh and move on? And there is no duty to hunt. There is, if you're in a clinical relationship, a duty to follow.
Bartha, I'm surprised that you aren't talking about a 4-part rather than a 3-part.
Yes, the test developers?
No, I'm actually thinking of the patients. Clinically, we often tell people, you know, if you want us to review, things are changing all the time. If you want us to review this in a year, come back to clinic. Is there not some responsibility along these lines for the, particularly in the concept of personalized medicine, where people are supposed to be controlling their own health information?
Yeah. Thanks for bringing that up. The more we move from populations to stratification and to subpopulations to families to persons or as individuals, we will be empowering patients. Patients are empowering themselves, that we know. But that also means, again, you're right, we probably should have what would be the correct word for 4-part responsibility. I think that will come for sure. It's often in law that's called contributory negligence. That is a known legal principle, yes. Sorry.
Thank you for the lovely and lucid talk. I hope I can take you off topic for just a moment. This year there was a law passed in Kuwait to forcibly collect DNA from visitors and citizens.
From what citizens?
From citizens, from its citizens and from visitors to the country, in Kuwait.
Yes.
And so, you know, in G4GH we often have the luxury of playing offense. We advocate for things. I wonder what you think our role is in preventing abuses of genetic data collection.
Thanks for that question. The Center for Genomics and Policy, if you go on our site, we have had someone who reads and speaks Arabic, because we have 8 languages, look at that law, examine. It is enforced, but it hasn't been used yet. It's a law that in Kuwait we're talking about, where potentially by looking at origins of persons, biological origins, for whatever, in quotes, legitimate purpose, you actually could trace family lines and say you're not a pure whatever, or you could say for immigration purposes you're out, or you could say for forensic purposes it was you. And this law has attracted, and there is a blog on the CGP website on that issue. The Regulatory and Ethics Working Group has not created or does not have a task force to look into potential misuse. But one thing I should say, we are thinking, in addition to the accountability policy, to looking at sanctions. Sanctions beyond the accountability policy for deliberate, intentional, and or negligent or malicious data breaches. Because that's where all the trust that we heard earlier this morning falls down. Everybody goes back into controlled access databases. So as we move to more public and more reliant and more responsible, we want to make sure that those who do not act as bona fide researchers are no longer going to be considered to be friendly hackers, whether they're Fancy Bear or whatever.